So the process of converting one entity to another entity, we call that as entity conversion. In 1956 Companies Act, the private company minimum was 2 and the maximum was 50. There are two documents which are very mandatory. One is Memorandum of Association and one more is Article of Association. Registered as well as written and documented. That is how you go for incorporation of a company. For a private company, the minimum subscription is 1 lakh rupees, and for a public company, the minimum subscription is 5 lakh rupees. Hello everybody, a warm welcome to one and all. I'm Abhilash Chandra from the Department of Commerce and Management in Vidhyaashram First State College, the Temple of Excellence. Welcome to all the students in the second session of the third chapter called as Company Formation and Conversion. So in the last session, we have explained you about how a public company limited can actually get converted to a private company. Now here we'll go with the next one, that is all about the conversion of one form of business entity into another. Now it can be any form, right? From any kind of a business form, you can actually convert it into a different form of the entity. So the first one here is the process of changing from one type of entity, for example a corporation, to an LCC, that is limited liability company, or vice versa, it can be a different one, is called entity conversion. What is that called as? It is called as entity conversion. If you get a question like what is entity conversion, you are supposed to go with the process of changing from one type to another, as well as vice versa. Like a corporation is there and the corporation want to convert itself to a limited liability company, then you call that as entity conversion. So the process of converting one entity to another entity, we call that as entity conversion. So next one, if you understand, companies can change their legal format. Now they can change the legal format whenever they require for n number of reasons. Actually they can go with it. So an LCC, that is a limited liability company, may want to convert a corporation to make easier the incorporation of a new shareholders, investors, or for tax purposes. A corporation can convert to a limited liability company, that is called LCC, to take advantage of the pass-through feature allowed to an LCC. So any corporation, if they really want to convert themselves into LCC, they can go with it. A question is that what is LCC? You are supposed to comment in the comment box. LCC is all about limited liability companies. Why they go for it? Because a corporation want to take the advantage of being a limited liability company, because corporation have so many other features which you have already studied in your previous semesters, and we know that the feature of a limited liability company is what? Whatever you do, separate legal entity will be there and your liability is always limited. That means whatever the unlimited liability happens in a corporations, you can actually convert into a limited liability and make sure that you go with a separate legal entity, and all the features of limited liability can be taken as an advantage. Incorporation of a company. How is that you will go with incorporation? Like registering a company. So any 7 or more persons. So when we go with this, whenever we go with incorporation of a company, now we are talking about a public company. So when we go with a public company, the minimum members for a public company is 7 and the maximum is unlimited. It is what? Unlimited. So any 7 or more person, 2 or more in case of private. So this is about public. And when we go with private company, the minimum is 2. And when we go with the maximum, I'll tell you, the maximum, it is 200. Now this is according to 2013 Companies Act. Which act? 2013. Earlier we had an act called 1956 Companies Act. In 1956 Companies Act, the private company minimum was 2 and the maximum was 50. But after 2013, whichever companies registered or whatever the companies they have, they are supposed to go with a mandatory kind of a thing, that is minimum is 2 and the maximum is 200. That means 150 members are included in 2013 Companies Act. So when we go for incorporation of a company, whether it is a public company or a private company, when you go with a public company, minimum 7 people or more they can actually come. For a private, it is minimum 2 or more, but less than 200 they are supposed to be there. May form an incorporated company for a lawful purpose. That means it should be what? Lawful. What does business? Buying and selling of goods and services on a regular cycle, plus the main motive is to earn profit, and it should be legal. So here how much it is? Like lawful purpose. By subscribing their name, what is it? By subscribing their names to the memorandum of association. Any incorporation, if you go with it, the document should be very clean and you are supposed to go with memorandum of association. What is the use of memorandum of association? This is a document where objectives will be given, and you have 6 clauses which I have done already in the session 1 of the first chapter, and session 2 also have done the entire process of memorandum of association. Please watch it. Next, here if we understand memorandum of association and complying with other requirement in respect of registration. Such an incorporation company may be a company with 3 qualities. One is limited by shares. A company can be formed by limited by shares, limited by guarantee, or one more is there, an unlimited company. Now you may be in a dilemma. Sir, how can a company be unlimited? Because company have a feature called limited liability. Yes, in 2013 we have also studied that we can actually go for unlimited liability. What is the advantage of registering a company into unlimited liability also I'll tell you, and what are the difficulties also I'll be explaining you in the next session. So incorporation of a company. Now the application for registration of a company should be presented to the registrar. Now we call that as ROC, Registrar of Companies, of the state in which state you are actually going and registering your company, in which the business office of a company is to be situated. The application for registration shall be accompanied by the following document. There are 2 documents which are very mandatory. One is memorandum of association and one more is article of association. So you have 2 of the document, memorandum and article. Next, when we go with it, the agreement, if any, which the company proposes to enter into with any individual for appointment as the managing director or whole-time director or manager, that should also be there. That is the agreement between who can be the managing director, that is the MD. And please understand here, MD is not selected, he is appointed. When he goes for appointment, what happens is his consent should be there. That is, voluntarily he should also accept the company's position, and he is supposed to give his signature. Now I'll be talking about more of signature, because you already know that the company secretary or the board of director or any of the managing director, they become the signatories and they are supposed to be present when the memorandum of association and the article of association is getting registered, right? The reason is their consent should be there. So when we go with the 4th step, what happens here is a statement of nominal capital should also be issued. That is, what is your nominal capital, how much is your investment, what type of a company you are going with, whether it is limited by shares, limited by guarantee, or it is unlimited things. Then a notice of the address of the registration office. Now what is that you should do is, you should understand that you need to give prior notice to the registered office. If you have not given the prior notice where your office is situated, after getting incorporation, you can actually take a time and then give it to them. That is 30 days before you are supposed to go, or 30 days after your registration you are supposed to go. A notice of the address of registration office of the company. This may be done within 30 days of registration if it cannot be filled at the time of registration. So you will get a time period of at least 30 days. That is a maximum. A list of directors and their consent to act signed by each. That is, all the directors and the people like signatories, they are supposed to give their consent saying that they are ready to actually incorporate the company. An undertaking in writing sign, that is, it should be written. It is not digital signature, it should be a written one by each such director to take and pay for his qualification shares. Now I explained the qualification share in the second chapter itself as well as in the first chapter. Please do watch it. If you know what exactly the qualification shares is, it is very easy for you to write more about it. A declaration that all the requirement of the act have been complied with. So all the things will be registered as well as written and documented. That is how you go for incorporation of a company. Next is certificate to commence of business. Now when you go for a certificate of commence, what really happens is, certificate of commence of business will be issued only when there is a clause. What are the clauses? The first one is, shares payable in cash have been allotted up to the amount of minimum subscription. Now when we go with minimum subscription, for a private company the minimum subscription is 1 lakh rupees, and for a public company the minimum subscription is 5 lakh rupees. The directors have paid in cash, and the application allotted money in respect to shares agreed to take by them in cash only. That is how the commencement can actually happen. That is, the directors have paid in cash the applications and allotment money in respect to shares agreed to be taken by them in cash only. They are not supposed to go with something else, they should go with the cash. So if you go with more of it, no money is or become liable to be refunded to the application or applicants. Now when you are paying in money and you are taking in cash, now what happens is, there is no liability, there is no kind of a thing for any share or debenture by reason of failure to apply for or to obtain permission for the shares or debentures to be dealt in any recognized stock exchange. So you are supposed to always register your company, and then you are supposed to go for a reputed and recognized stock exchange. The company has filed a prospectus or statement in lieu of prospectus. Now a private company cannot issue prospectus, it is only the public company which issues a prospectus. A statutory declaration that is signed by any director or secretary, company secretary of the company, that the above requirement have been complied with, have been filed with the registrar of companies. So where you are supposed to go, that is the ROC, registrar of companies. So when you go with all these procedures, see, I'll tell you, I have given you few of the points of how the commencement of business will actually happen. It's a very long process. It is not very easy the way I just told you here. You are supposed to understand that how many people should be there, what exactly a type of company it is, what is that you're gonna write in the memorandum of association, what exactly the internal management rules and regulation of article of association, are you going with the objective and you are actually practicing the same, or is there any problem with the company in the locality or in the future. Everything they'll actually go with it, and then only the registrar of company will go for the commencement of business certificate. Now procedure for incorporation of a private company. Now how a incorporation will happen for a private company, understand this. Acquiring DSC for directors and subscriber. Now what is DSC? Digital signatory certificate. Now you don't have a written signature, you have a digital signatory certificate. Obtain DIN for directors. DIN in the sense directors identification number. Name approval application. Next is application for certificate of incorporation, and the last one is formulation of memorandum of association and article of association. So this is how a private company will go for incorporation. When we compare public company and a private company, what happens is it's very difficult to incorporate a public company than a private company, because formalities are too much in a public company than the private company. But when we understand only private company, I'll tell you, it is not just these 5 things. The registrar of company can actually dismiss this incorporation itself if the documents and few of the legal things are not met by the private organization. That's why we are supposed to be very careful when we go for a proper registration of a private company. Any doubt you have in this session, please do call us. We are always there to help you. Thank you so much. I'll see you when I see you.